Good day, ladies and gentlemen, and welcome to this week's LawCast. Today what we're going to discuss is a case out of the United States Court of Appeals for the Ninth Circuit. Yes, I know, the Ninth Circuit. The mere mention of the fact probably means that I'll be laughed out of every court in Virginia. But it's a good decision. It's a textually oriented decision. First noted on how appealing, and later was kind of questions were raised about it by Oren Kerr at the Volokh conspiracy. The author of the opinion is Alex Kaczynski, and, well, let me see if I can find his conclusion here, and I'll read it out to you. Okay. Now, what makes this opinion seem so spectacular is the final opinion, or the way the opinion is written in the end, the conclusion it's come to. No rational trier of fact could have found that Golden committed the crime of writing bad checks as defined by Nevada law, and no rational judicial system would have upheld her conviction. We are saddened and disappointed that the state Supreme Court unanimously affirmed a conviction carrying multiple life sentences based on such a cursory and inadequate review of the record in light of the applicable statute. Pretty damning way to talk about a lower court. You have to realize, however, that that's the standard that's set under a case called I think it's Jackson against Virginia, originating in my home county, Chesterfield County. Jackson raised the issue whether or not proof beyond a reasonable doubt was necessary in all elements, every single element of a case for due process to be complied with. The court said yes, and then said, but it was in your case anyway. The basic rule, well, basically what the judge is deciding, what Judge Kaczynski is deciding, is whether or not due process is violated because no rational finder of fact could have found that there were facts sufficient here. And what he does is he goes back and he looks at the statute. And first of all, let me give you the situation. Golden, the defendant here, uses a fake name, goes to a bank, gets a line of credit for $500. I think she gets a loan for $1,000, a line of credit for $500, a checking account, and a check cashing card, which I guess a check guarantee card, which as long as she had that card and card was valid, the bank would honor any check she wrote, so she could write checks, to any bank. It's an older thing. You don't see this anymore, but it was done to say, okay, her checks are good. So what she did was, well, she spent the $1,000. She spent the $500. She then spent more. She kept writing checks, and she was using this card saying, the checks are valid because I have this card, and everybody was cashing them, and the bank was honoring them because she had the cards. And there's some talk about whether or not the bank sent her a letter that she was no longer supposed to cash checks. However it works out, the bank never canceled her card, so it was valid for all the checks she cashed, despite the fact that she didn't have any money left in her account. So the statute in question is what Judge Kaczynski reads. And just one second and I'll read that to you. Okay, the statute in question is Nevada Revised Statute 205.130, Section 1. A person, and you violate this statute, which is basically fraudulent writing of checks, if a person willfully, with intent to defraud, draws or passes a check or draft to obtain money or property when the person has insufficient money, property, or credit with the drawee of the instrument to pay it in full upon presentation. Credit is defined as an arrangement or understanding with a person, firm, corporation, bank, or depository for the payment of a check or other instrument. So what basically her defense at trial, the defendant's defense at trial, is that I had credit. They had given me this bank card. They were honoring the checks. I had credit. Well, and it goes further, because during trial, an employee from the bank is put on the stand and questioned about this. And the questioning is laid out here in the habeas decision. Question: the $500 line of credit was, you previously testified, attached to Golden's checking account. Is that right? Answer: that's correct. Question: and is that a type of overdraft protection? Answer: yes, it is. And here's where you get to the meat of the matter. Question: and could a member extend the credit line beyond $500 without approval from the bank? And the answer to that is, ladies and gentlemen, if I can get the page turned. Answer: they could. Question: how? Answer: by exceeding the amount of $500 and continuing to write checks. So basically, as long as she had the check card and she wrote checks, and the bank hadn't canceled the check card with notice and all that good stuff, she had credit. And, however, she's found guilty at the trial court. I think they say she went through 7 levels of appeals, including, the appellate courts in Nevada, and I think a couple times, probably including state habeas, and then the district court for the district federal court, all of which deny her appeal, or deny her redress in these things. So she gets, because she's a multiple offender, she gets 3 life sentences, which apparently in Nevada means you serve 12 years, because she's out of prison when by the time Judge Kaczynski gets this, and he has to go through some sort of explanation as to how they can still hear this case. Now, from that point on, he looks at the statute and he says, okay, it says if she's got credit, you can't convict her of this. Points to that and says, well, she had credit. It was explained at trial she had credit. There's no way any rational person, any rational trier of fact, can say she didn't have credit. But it's there. I mean, it's pretty clear. And he goes on to talk about how the bank's remedy is actually civil. I don't know about that. And to be honest with you, this is not someone you feel extremely sorry for, because if they hadn't convicted the defendant of this, I'm sure there's another charge, some sort of fraud on the bank or something that they could have brought, theft charge maybe, some sort of theft charge, whatever. They probably could have brought another charge, but she was incorrectly charged on this matter and should not have been convicted under the statute she was charged upon. And that's what the judge comes to his decision to. He says, it doesn't apply. She spent 12 years in prison for something she shouldn't have spent 12 years in prison for, and we hereby, wash the record, clear her good name, and, send her forth to sin no more. So that's what they do. It's interesting. Now, and I think the judge is absolutely right. Reading the statute, if you read the plain language of the statute, it is, if she has credit, and she had credit, as explained by the bank employee during the trial, she could extend her credit as long as she had that check cashing card. She could extend her credit pretty much without limit. It's a pretty stupid thing for the bank to do, and obviously the bank didn't check to make sure she really was who she said she was before they gave her this line of credit and the check cashing card. Otherwise, one would hope banks aren't in the practice of giving things to people who give false names and have a record. Who knows? Maybe this bank is. Anyway, as you apply the statute, it doesn't apply. It's not applicable. And under Jackson against Virginia, since no rational trier of fact could have found that that statute was applicable, then then due process calls for dismissal of all of this. Now, Orrin Kerr over at Law Conspiracy raises the next day after How Appealing had talked about it, the issue of whether or not the Ninth Circuit in the body of its appellate courts actually had the right to do this, because previously the law in Nevada had been defined by its own Supreme Court, and it hadn't been defined the way the statute wrote. Now, hold on a second, I'll get this for you. So Orrin talks about a case that he found in the Nevada Supreme Court, Garnick against Frist first, and in that case, the Nevada Supreme Court said that this statute applies if there's an intent to defraud, there's the making or passing of a check for the payment of money, and the person is without sufficient funds in the drawee institution to cover said check in full upon its presentation. And Orrin wonders whether or not Judge Kaczynski is fudging here, because he's not following the interpretation that the Supreme Court of Nevada has put upon this statute. What I would say to that is pretty much what Judge Kaczynski said to it. It's sad that when the statute clearly says that a certain element is there, a certain element must be fulfilled, that the Supreme Court of a state would slice that element out of the black letter law. And I think you end up in the same place, same exact place. The application of the law as the Supreme Court of Nevada did it was wrong. They sliced an element out. They convicted someone of something when the law clearly was the other way. The law clearly said that if you had credit, and credit is well, I guess you could stretch sufficient funds to say credit. And that's another possible reading of it. You could stretch that to say, if there's sufficient funds available, which would be a credit line, which would be the credit line from the check card. If you have sufficient funds available, then you're good to go. If it's more narrow and it actually means the amount of money that you cash a check for, well, then the state court is wrong, because it's ignoring the black letter law. And Judge Kaczynski goes in and says, no, you can't do that. The law says this. It is clear and unambiguous. And if you change the law in case law from the clear and unambiguous meaning of it to convict people, well, then you violate due process. Because nobody could convict this person under the law as it's written. It can only be convicted under the law as you have construed it, which ignores the law as written. And I think he's right there. I think that is pretty clearly a due process violation. I wonder how often that sort of thing happens, where a court appellate or a Supreme Court of a state actually ignores part of the law or rewrites part of the law. I know there are a couple statutes that I can think of in Virginia where they've done that. And wonder how often we're going to find judges and justices in the appellate courts with the wherewithal to stand up and say, look, no, you're wrong. It's not written that way in the statute, therefore you can't convict somebody of it. I doubt, particularly in Virginia, since we don't have a three strikes law, that on more minor offenses like this it'll ever make it as far as this one did. So if a court of appeals in Virginia were to do something like this, I doubt, unless it's a murder charge, that we're ever going to see it in the appellate circuit courts in the federal circuit or in federal district courts, because Were somebody to do check fraud here, they'd probably get a year, 2 years. If the judge just went absolutely nuts, 5. And so it really wouldn't make much sense to appeal it through a habeas through the circuit court, because that would be years after you had finished whatever time you'd served. And getting a little bit back more on point, I think Judge Kaczynski has it right. And I think this is a prime and perfect example of how you read the text. And this one didn't even really need a whole lot of interpretation. There wasn't use of interpretation tools here. There wasn't, exclusio unius est, or inclusio unius est exclusio alterius, or any of those sorts of things. This is plain meaning. He read the plain meaning of the statute, he applied it, and then he said, under due process in the United States of America, plain meaning of the statute means what it says and says what it means, and therefore you can't convict this person. And I applaud him for doing that. And ladies and gentlemen, that's it for today. Hope to see you soon.